Is it Miss Harvey or is it Miss Norton? Because the secretariat is a bit confused and they're confusing me along with them.
Yes, Chief Justice, it's Ms. Harvey.
It's exactly the person we want to talk to right now. Okay. Are you well, Miss Harvey?
I'm well, Chief Justice, yes, thank you.
Good.
I hope you are too.
All right, let's start with this interview of yours. You practice at the Cape Bar since 2010
Yes,
as an advocate.
that's correct.
But before that, you had a whole other life. You started out you obtained a degree in civil engineering, worked in that field, cut your teeth in trade unionism and other interesting things, and then almost 2 decades later decided to come to this noble profession.
That's correct, Chief Justice.
All right. So you hold this BSc Civil Engineering degree, which you obtained from Wits.
That's right.
And then when you decided to join the law, you studied for an LLB and later an LLM, which you acquired both with distinction. Well, all your academic qualifications were obtained cum laude.
Well, I think the one cum laude, the other with distinction, yes.
Oh, I see. Well, what's the difference? Okay. So what kind of work did you do with the trade unions? Because I see that there may be relevant experience to be gleaned from that time.
Chief Justice, the first trade union that I worked for was Sakau, and in Sakau I worked for the legal unit in the Wits branch, and that was representing union members at the industrial court in Pretoria and in IMSA private arbitrations. And after Sakau, I was then recruited by NUMSA, National Union of Metal Workers, and then I worked as a local organizer in the Wits East branch of NUMSA, organizing workers at factory level. And I did that until the 1994 elections.
All right. But that was even before you studied law, in the 80s, 90s?
Yes, that was before I studied law. I only studied law in my 40s, Chief Justice.
Yeah.
And that was after I'd had a lot of quasi-judicial exposure through the CCMA and the bargaining councils after the 1995 LRA was enacted.
All right. So what kind of practice have you been running as an advocate?
As an advocate, it's been quite mixed. Most of my practice has been a labor law practice.
Excuse me just one moment. There's chatter that's coming from this corner that I find most disruptive. Secretariat, would you please? Yeah. Go around. I think you can go through the curtains. Okay, where were we?
I think you asked me which areas of law I practiced
Yes.
in at the Cape Bar, Chief Justice. It's been mainly employment law. That's been where I've received most of my briefs because it's the area that I'm best known in. And I've had the pleasure of doing some quite impactful cases in the Constitutional Court. But I've also been able to do other areas of law that's been really interesting, such as refugee law, other types of human rights law, equality court matters, and a little bit of contract and delict as well thrown into the mix. So I've had a really enjoyable and mixed practice at the Cape Bar.
But the bulk of your work is in the area of labor law.
It is, yes.
You appear in all the courts, all the way from the High Court to the Constitutional Court.
That's correct, Chief Justice.
You've appeared in the Constitutional Court, as you say, 3 times.
Yes.
In which matters?
So the first matter, I was a junior advocate in the matter of Florence versus the government, which was a matter about land restitution. and the proper calculation of the monetary value of land that couldn't be restored to land claimants. And the second case was the assigned services case, which had to do with the interpretation of the amendment to the LRA to do with the rights of non-standard employees, in particular labor broker workers. And the third one was the Dunlop case, Chief Justice, which dealt with the concept of derivative misconduct.
Did things go your way?
They did, Chief Justice, yes, certainly in the two labor cases. The Florence case was not successful.
Right. You win some, you lose some. How long have you acted as a judge?
Chief Justice, I've acted for a total period of only 7 weeks. But to add to
In
that,
the labor court?
In the labor court, yes. To add to that, however, I do bring quasi-judicial experience spanning over 25 years. And I believe that that experience is relevant as a senior CCMA commissioner, a bargaining council commissioner, a private arbitrator, because in those proceedings, one develops many of the same skills required of a judge, including running the procedure, becoming familiar and comfortable with the rules of evidence, and engaging with legal representatives, including laypersons, especially at the CCMA. And during that time, I've issued hundreds of arbitration awards, in the process learning many of the core skills required of a judge, distilling the issues, identifying the applicable law, and writing a clearly reasoned outcome that above all shows the losing party that their case has been properly heard and appreciated. So when I stepped into my first acting stint as a labor court judge, I found myself well prepared for the role, and approximately 50 labor court cases were allocated to me over those 7 weeks, and I've handed down 26 written judgments, and I'm proud to say 5 fully reasoned ex tempore judgments, which I realized as counsel watching labor court judges is a useful skill for a labor court judge to have if she is to stay on top of her review workload. I think I came to the labor court feeling very at ease with the environment. I found it easy to settle in and to manage the procedure and to engage with counsel. And I suppose that was also helped by having practiced extensively in that court over the past 14 years as counsel. So I'm familiar with the protocols and the procedures. And I think as counsel also frequently drafting well-reasoned, clearly researched heads of argument also helps to develop the skills required for writing judgments. So the 7 weeks is not a very long time, Chief Justice, but I believe it has prepared me well, and that my track record shows that I can produce well-reasoned, properly researched judgments on time, and therefore I feel that I am ready.
Well, you preempted my question, my next question, because I was going to put to you the views expressed by, I think, at least 2 professional bodies, SAULA and the BLA, who think you could benefit from more acting time in the labor court. But you've answered, and I think you've answered fully. Maybe I should bring this to your attention as well, because I'm at that page. The BLA makes an observation that you have not demonstrated any role you may have played in the transformation agenda of the legal profession. And I look at the other things that you've listed in your CV, and I think you might have an answer for this criticism. What would you want to say to this, if anything?
Yes, thank you, Chief Justice. I did see the comment. I have contributed to transformation in a few ways, both within the bar, which I think is the focus of interest of the question, and also more broadly through my work on access to justice. Just starting with the bar, my main contribution has been to advocacy training. So that has been to attend a 5-day residential course to qualify as an advocacy trainer, and then spending many hours as a member of faculty training pupils who are selected in line with the Cape Bar's transformation agenda. And the training that is given to pupils includes intensive one-on-one coaching to help them to develop their oral advocacy skills, and also feedback on their written advocacy skills, such as pleadings and heads of argument. I've also contributed to Cape Bar committees. In the early years, I sat on the mediation committee. I've also sat on the council and on various disciplinary subcommittees, and at the moment, I'm a member of the fee dispute committee of the Cape Bar. And when it comes to briefing patterns, Chief Justice, because I know that this commission is interested in that, I am a junior myself, and I have never been briefed with a junior. And aside from recommending excellent black female counsel to attorneys, I haven't been in a position to influence briefing patterns. But I have always been keen to mentor juniors who are interested in labor law. I have found that it isn't the most sought-after area of law that young advocates want to get involved in, but where they have shown interest, in two matters, I have split both the work and the oral argument with those juniors so that they would get real substantive experience, and in those cases I've also split my fees. But Chief Justice, as you alluded to, my main contribution to transformation has been through my work on access to justice. And that is because I feel that if we are to transform the profession, we need to do more than improve access to work. We also need to improve access to be heard. And that's because if there are groups who are routinely not heard by our courts or are excluded for one reason or another, then our courts will not be in a position to develop the common law in the way that the Constitution wants courts to do. So, since I've been at the Cape Bar, my main work in support of access to justice has been firstly in pro bono hours spent on impactful cases, such as the Uber case and the case amending Rule 25 of the CCMA rules to permit broader representation. And then allied to that, trying to build capacity in the main legal NGOs, LHR, LRC, and in community advice offices, so that legal representation is more broadly available to the community at large. And in that respect, that kind of segues into a special interest that I have in the issue of language, Chief Justice, because I believe that access to justice also means that a person needs to be properly and fully heard in court, but perhaps I should address that later. I think my answer has been pretty long as it is.
All right. You don't have any reserved judgments, do you?
I do not, Chief Justice.
All right. I would have liked to hear a little bit about your ability to speak African languages, but if you want to defer it, we're in your hands.
It's really about the intersection between language and power. It's something that's interested me. When I left school, I lived in Botswana for a year in order to learn how to speak Setswana. And I experienced firsthand how deeply disempowering it was not to be able to express myself eloquently in the language that was being spoken around me. I felt that I was sort of lost in translation. I couldn't really show up as my full self because I couldn't express everything that I wanted to say. In fact, I felt almost childlike. And that made me very acutely aware from then on, and I was only 17 years old at the time, of how much language and power intersected in South Africa, and how language could be a barrier to accessing justice and to accessing institutions. It obviously helped me in the trade union movement, Chief Justice, but when I got to the CCMA, I quite frequently noticed that weak interpretation undermined a person's right to be heard. And of course, that links back to my first point, which is that if courts cannot hear fully and properly the full nature of all South Africans' experience and perspectives, then it's not just the litigants who are deprived of a fair hearing, but it's the courts themselves that are deprived of an opportunity to develop the common law in the image of everyone in our country. So I'm very passionate about language as an issue. I know there's various things that can and can't be done about it, but that is what I wanted to say about language. Chief Justice, thank you.
All right, thank you. Judge President Mlahle.
Thank you, Chief Justice. Good afternoon, Ms. Harvey.
Afternoon, Judge President.
How are you?
I'm managing.
I should be say Dumela.
Dumela.
O tsogile.
Ke tsogile.
Ke a leboga. I see your practice is about 85% labor, and you do other things which we'll talk to later on. But before we go in there, let's talk about the most important thing. If you are successful, I see you've applied for both Cape Town and Johannesburg. That's going to be easy for you to relocate because I see you are resident in the Cape.
Yes, thank you, Judge President. I was born in Johannesburg. I grew up in Joburg. I spent more than half my life there. And I'm fully prepared to return to Johannesburg if that's where you, as Judge President, would like to deploy me. That is not going to be a problem for me. I feel very comfortable in Joburg, and in fact, it is my home.
Okay.
So, yes.
It's quite important because I've seen over my period serving in the labor courthouse, this traveling and relocation can be frustrating for individuals because it's not only you, it's the family and everybody around you.
Yes, Judge President. One of the reasons that I'm so prepared to relocate at this point is that both of my children are grown. They do live in Cape Town, but I'm really free to move as I please.
Okay.
And when I went back to university to study for my law degree in my mid-40s, it was precisely because I had the aspiration to attain the experience and the qualifications to become a judge.
Okay.
And so a judicial appointment is more important to me than the location.
Okay. And you realize that you have actually traveled between Cape and Johannesburg. I think you did Cape Town and Durban. You've done the 3 courts.
Yes, Judge President.
And you have no problem with it.
I have no problem with that, Judge President. In fact, I love traveling from court to court. The CCMA also used to send us around the country.
Yes.
And I find that the quality and the types of disputes are different in different areas. And it really adds to the variety of the work.
And the traveling is likely to increase because with the limited number of judges we have, we may require you to go to Limpopo, we may require you to go to Mpumalanga, and next to that it's likely to be Northwest and the George area.
I would really welcome that, Judge President.
Okay. And talking about the George area being from the Cape, what is your view about the court being only in Cape Town city itself? And have you experienced people not being able to access the court simply because they have to travel long distances?
I haven't experienced that personally, Judge President, but it's obvious that the fewer seats of the Labour Court that we have and the fewer seats of the CCMA and the bargaining councils, the more difficult it will be, especially for vulnerable persons to access.
Okay. And have you looked at the manual for acting judges?
I had the manual sent to me, but only after my last acting stint.
Oh,
Judge
really?
President.
I'm sorry to hear that. But have you had a chance to look at it?
I have, Judge President, and I understand that there's a concern about tea room attendance, if I may
Yes.
preempt your question.
Yes.
The main answer to that question, Judge President, is I went to the tea room once or twice during the week that I acted in Johannesburg, but on both occasions nobody else was there. And I think that's because there was a shortage of courts during that week. And on most days, I had to wait for another judge to finish in a court before I and my parties could then take over that court and deal with the cases. So I wasn't on a usual court schedule. I think I was probably starting at about 11 or 12 and just working straight through. When I saw the manual, I then realized that tea room attendance is valued in Johannesburg, and I would greatly value that. I do think that that sort of informal collegiality between the colleagues is important and necessary, and if I'm given the opportunity to act again, I will definitely
Yes.
go to
It's
the tea room.
it's in fact not only Johannesburg, it's all the courts. Even though Cape Town you would have 2 judges, the same with Durban, and 1 judge in Gqeberha. And I have noticed when I visited some of these courts that judges where there are only 2, they don't attend tea. Whereas when I was in Gqeberha, 2 cases arose where we needed another judge to step in. And that's one of the values of attending tea. That for me, either as a JP or the senior judge would be able to say, yes, here you are, could you come to tea? I won't take point with you being in tea alone, but that week I was in Johannesburg and attended every single tea. And I saw you on the Friday as you were leaving. That's when I was walking to tea. But I'm not going to argue your point that you were in there alone. Sometimes judges come late and whatever, but it is important.
I take the point, JP.
Thank you. I see you appear also in a range of matters, and I think you've already made the point in answering to the Chief Justice question. You've dealt with derivative matters, you've dealt with disputing between in labor brokers, constitutional equality case in the education sector, and you list a whole long list of cases that you've attended to or dealt with. Now, your acting stint, also you've touched on that. From my record, you acted between July and August 2024, and you acted pro bono 1 week and another 1 week pro bono. And I must thank you for that, because we called you at a very short list time to say we were faced with a challenge. Could you come in? Your total acting stint is about 30 days from my side. And in your acting stint, did you do urgent cases?
Yes, JP.
And did you do them through Court Online or still the old system?
It was still the old system.
So you're not yet trained in the Court Online system?
I'm not.
Okay. And in terms of the virtual hearing, we've just dealt with the issue of access and trying to make sure by other means people will have access to court. Have you used the virtual court system?
Judge President, in my first acting stint, I think that was in 2021, it was during COVID, and we did all the cases online at that time. I think that's a different system to the one that we use now. I haven't done any virtual hearings in my last acting stint, JP, but obviously I've appeared in virtual hearings as counsel.
Yes.
So I'm familiar with the process from that side of the table, as it were.
And what is your view about the usage of virtual hearing, particularly in relation to access to justice? Some people have argued that it actually limits the access to justice.
That's a difficult one. Obviously, it improves access where people can't travel, but limits it where people don't have access to data or the technological interface. I had a matter, I think it was a pre-trial conference in the Cape Town court, where I think the attorneys were in Johannesburg and the applicant was in Cape Town, and they wanted to do the pre-trial conference. It was a judge-chaired pre-trial. They wanted to do it on the virtual platform, and we managed to get the applicant to come into the court, and the registrar set the applicant up with a screen. So I suppose if the Labour Court were to spread itself throughout more centres, and then were to make virtual access available to litigants in those centres by providing the technology and the data and interface, then I suppose it would improve access to some extent, although I personally don't prefer the virtual platform. I prefer the in-person.
But don't you think it would also help with the point you've just raised about judges having to wait for another judge to complain, which I must tell you personally, It frustrates me. I feel very offended having to wait for the court. And it actually causes tensions between the judges, because one judge will say, I'll be finished by tea time. And we know how cases unravel. By 1 o'clock it's not done, and you're still waiting. Isn't that also another way of addressing that particular problem that we're having in the labor court?
Yes, I take that point, Judge President. I personally didn't feel offended, but I suppose that's because I was just a junior and an acting judge, and so I expected to come later. But
Okay.
I understand your point, and I think it's a valid one.
Okay. And if I take into account, yes, I do hear you when you say that you have an extended period of involvement in labor matters. You do appear quite frequently in labor matters, and your practice centers around labor in essence, and you've got a long history of it. But what would you say if I was to say, looking at your period of acting, it seems to me we may need to offer you, if you're not successful, a further acting stint. What would your attitude be?
Of course, if I'm not successful, Judge President, I would very much welcome the opportunity to do further acting stints.
Okay. Thank you very much, Chief Justice.
Thank you, Judge President. Colleagues from NETLAC, do you have questions? None. All right. Minister?
Thank you very much. Let me start to where some of the questions were asked. And start, good afternoon, Advocate Harvey.
Good afternoon, Commissioner.
On your response or your questionnaire, you've got Golden Arrow Bus Service versus another and versus and the Minister of Employment and Labor. And you've listed this case as a reportable case. Is it an error of judgment?
I'm not quite sure if I understand the question.
It is definitely not reportable, but you've listed it as reportable. So I'm asking whether it was an error or you were cognizant, or what could be the reason that it was.
Is
on
that
the
in the
list.
list of cases where I've appeared as counsel?
Move the mic closer to you.
Is that in the list of cases where I've appeared as counsel? It's certainly not a judgment that I've issued. I'm just maybe
Trying to understand your response.
maybe you could take me to the page in the bundle which you're referring to, because I'm not understanding the question.
Okay, on page 20,
Yes.
if you look at there, because they are saying, give us reported judgments that would have been part of, and you are saying as per an advocate. But I'm saying the first one that you have listed there, you've listed as reported, but it's not.
So these are cases, or these are judgments in which I appeared as counsel, and that Golden Arrow bus service case is reported because the citation is there. It's been reported at 44 ILJ 1715. So these are cases that I have found in the law reports in which I've appeared as counsel, and it's definitely a reported case, Commissioner.
Okay, because I've looked at it, I found it not to be. But let's move on. The issue, because one of the issues that you're making reference to, and I think one would have to, while I acknowledge your commitment and explanation, as CJ was asking you about the time you've spent acting and the expectations thereof, and your explanation. And I must say, this, as a person who does the work, I'm inspired by you, because as much as my work takes me everywhere, I would love traveling and not have a problem with it, leaving my family, my partner. It's such an inconvenience to be able to do, because one day I'm expected to be in Limpopo, in Mpumalanga and Kampek. It just destabilizes your life. and your health never gets to be a bit organized. So that's what I'm saying. From your comments, I think I'm a bit inspired to hear that you don't mind that at all, and you don't find it as an inconvenience. Let me come to the issue around what you think that efforts that are necessary for us to be able to transform our judiciary, and it's also linked to what the question was asked by the President in terms of utilization of virtual platforms as part of access to justice, but where the courts are located and the people that are meant to be served. What do you think should improve in that regard?
Commissioner, the question of access to justice, I think, is almost a crisis in our country at the moment, and there are a number of different ways that it needs to be addressed. One issue is that employees and ordinary citizens are, to a large extent, unrepresented. Union membership has dropped, I believe, below about 20%. And there are many, many employees. We're talking about employees here because they're people who will be wanting to access labor law justice, who don't have any access to any form of representation. So I think that expanding forms of representation is one of the ways that one would improve access to justice. Expanding the seats of the Labour Court, as the JP raised with me, I think that will assist, as well as the virtual platforms if the resources are supplied. And then, yes, I do think that a transformed judiciary, or a judiciary which is able to hear people in their own languages, is important. I know this is possibly a controversial policy question, and I understand that English is the main language of the courts. But of course, if somebody hasn't had proper interpretation in a lower tribunal, and the record on review or on appeal is only in English and goes up to the next level of tribunal, then whatever shortcomings the original interpretation had, then just carry on going up through the system. And so I think that a lot of attention could be paid to professionalizing, either to running processes in South African languages and not only in English, or to putting a lot of attention into professionalizing interpretation in employment law matters.
Professor Murumakhay?
Thank you very much, CJ. Good afternoon, Advocate Harvey.
Good afternoon, Commissioner.
I have two questions for you. One is more substantive, and the other one, it is just out of curiosity. Let me start with the more substantive one. In your questionnaire, in the paginated page 23, there is a judgment that you, and I must commend you for that judgment, because my understanding, you'll correct me if I'm wrong, is that it's not necessarily easy not necessarily to prove constructive dismissal cases, but to win them. Because of this concept, they are not inherently unfair, which I've never understood. And this judgment was delivered in the height of COVID, in circumstances where, in this case, an employee was forced to take a salary cut of 25%. And generally around that time, you found that most employees, or some employees, were laid off somewhere, were said, look, can you please go home, we cannot do anything, you can come back after whatever time. So even though there were companies that were genuinely going through difficult challenges, there were those who were taking chances. And I think this is what you were kind of like dealing with here, because there was no evidence of a company not actually doing well. In fact, in the previous year, they did well. And that's why this actually was able to pass. The question that I have for you is, when one looks at the jurisprudence of constructive dismissal in South Africa, and the test that is provided for in Section 186, subsection 1E of the Labour Relations Act, can employees adequately rely on the remedy of constructive dismissal in South Africa, or is this just a toothless remedy that we have in this country?
It is a difficult area of law because, of course, an employee who resigns and then claims a constructive dismissal takes a big risk that they're not going to be found to have been dismissed. So I wouldn't call it a toothless remedy. It's certainly one of the more difficult remedies to access. And I think that's why I found this case so interesting, because for a long time I had also struggled with the concept of, if you were put in a position where you resigned because of intolerability, why wouldn't it necessarily follow that that was unfair? And I understood that perhaps you could be put in an intolerable position, but that the employer was as fair as it could be when it put you in that position. So it was always difficult for me, actually, when I was before I got to this judgment, to really draw out those two strands. And I think that when I really had to sit and analyze this situation, I realized that objective intolerability went to the employee's experience, and that unfairness went to the employer's response, so that an employer could respond fairly, in theory, to an employee's objectively intolerable circumstance, or an employer could respond unfairly to that circumstance. And I hope that that judgment made it easier. It certainly made it easier for me to think it through subsequent to that. I hope that it would make it easier then to do the analysis, to look firstly at the experience of the employee, and then to look fairly at the response of the employer, and to separate the test out like that.
Yeah. No, well, the facts allowed you to do that.
Yes.
My second question, or the second question that I have for you is, when the CJ was leading you on the question of transformation, I'm not going to take you to task with transformation. You said something that really made me kind of like be interested. When you said that there are times where you recommend excellent black females. I just want to ask you, because we often hear this word, something being put next to either black females or black men, when you are dealing with the issue of merit in South Africa. Like, for instance, you never hear excellent white female or excellent white male. Like, was it necessary to say excellent black female? I mean, what motivates that?
I would like to think that people who think highly of my work would say that I'm an excellent white counsel. One wouldn't recommend somebody who's not excellent. I think that is why I used that descriptor. But I take your point, that it is possibly an implication in that phrase that makes it sound as though most black female counsel are not excellent. I take your point.
Thank you. Thank you, CJ.
Commissioner Mangen?
Thank you, Chief Justice. Good afternoon, Advocate Harvey.
Good afternoon, Commissioner.
Yes, I also want to canvass a point with you on this case of Wesco, where you dealt with constructive dismissal. But I want to talk to you about the remedy for constructive dismissal. The commissioner had actually awarded compensation of 6 months, having found that the dismissal did take place due to intolerable working conditions. Now, what I want to establish from you is, are there instances where, arising out of a constructive dismissal, reinstatement can be a competent remedy?
Yes, thank you. It's an unusual remedy because usually the relationship is found to be intolerable by the employee. But I do think there are circumstances when a person could be reinstated. I think once or twice I've come across circumstances in my role as counsel where intolerability was, for instance, caused by bullying or harassing behavior by some superior, and that if that person either left or was moved into a different department, then the employee would be able to return to work. And it always depends on what the employee wants, what they ask for in the CCMA. If they ask to be reinstated, then reinstatement needs to be seriously considered. So no, I don't believe that reinstatement is completely out of the question. In a constructive dismissal, I don't think I've seen a case where a constructively dismissed person was reinstated.
Now, if I can just follow up slightly on this aspect. In the context of this case, as I understand it, the issue was arising out of a salary card, really, which impacted on the wellness of the employee and leading to financial distress because the family was suffering because he was working reduced hours. And then he resigned as a result of that salary card. Isn't it an instance where once the financial position of the company improves and COVID had passed, and that there was no need for then the company to experience financial difficulties, the employee can actually be able to go back into his or her position?
Yes, on the facts, Commissioner, I'm sure that would have been possible, but that wasn't the claim.
Thank you, CJ.
All right. Commissioner Chairperson.
Thank you, CJ. Good afternoon, Advocate.
Good afternoon.
My question is actually probed by the statement made by Professor Marumahai when he asked you the first question. Based on what he said, I just want to ask you, how would you balance the constitutional right for fair labor practice vis-a-vis the economic realities facing businesses, especially in this struggling economy?
So I think that the question is about fairness. We're talking about fair labor practices. And when one considers fairness, one's looking at the conduct of an employer and whether it respects the dignity and the personhood of the employee. We don't live in a fair or an equal society, and so the right to fair labor practices doesn't fix all of that. So one looks at the tests for fairness, and one weighs up the conduct of the employer and evaluates whether it's been fair or not. And as was said in Siduma, when it comes to a CCMA commissioner, that depends on, it's a value judgment, and that depends on the sense of fairness of the commissioner or, in other cases, of the judge. I'm not sure if that answers your question, Commissioner.
President Molemele. Have you finished, Commissioner Amche? I'm so sorry.
Thank you, CJ. But then the question, the statement that he made, it has got nothing to the right or wrongdoing of the employee. But in the main, it's a situation that might have been created by the economies of scale at the time. So here's the person who's earning so much, and willy-nilly or for whatever reason, his salary has been reduced by 25%. And in my assumption, I would assume due to economy or the financial collapse of that particular company. Now, where do you draw the balance between the two?
Yes, absolutely. That does go to the facts of this matter. Absolutely, if the company had been able to show, and if the company had claimed that it was in genuine financial distress, then it may well have been that the conduct of the company, although intolerable to the employee, was nevertheless fair. And that is the inquiry that I undertook in the second phase of my reasoning. And on the facts, the employee had approached the company, had said that she couldn't afford to take the cut, and had given the company an opportunity to explain its finances to her. And the employee had also, if I could recall correctly, and it is in the judgment, the employee had brought to the company's attention its good financial performance in the previous year, which this employee happened to know about given her position. And I took all of those aspects into consideration, Commissioner. And I think the implication of that certainly is that if the company had been in genuine financial distress, then the interests of fairness would have supported a finding that although it was intolerable to the employee, it was nevertheless a fair, constructive dismissal.
No, thank you very much, CJ.
President Mulemel.
Thank you, CJ. Good afternoon, Advocate Harvey.
Good afternoon.
I'm over here.
Could you wave?
Right
Thank
here.
you, thank you.
Yes, you referred to the well-known case of judgment of Sidumo, and I think other candidates have done the same. One thing remarkable about that case is that I think if it doesn't hold the record, it's one of those. But I mean, it was in the courts for more than 20 years, between the date of dismissal and the date of finalization by the Constitutional Court. Now, Sidumo happened long before the era of CONAB. And one of the reasons why CONAB was introduced was try to expedite the process. Now, the previous candidate indicated that there's one matter that he was involved in where the employee in question was dismissed in 2019 and the matter has still not been finalized. Two questions that I'm posing to you is, what is your experience in as far as the finalization of matters is concerned? Do we have lots of those where by the time you hear the review, the employee was dismissed more than 5 years ago, for example? And would you say that CONAB has been beneficial, has served the purpose it was intended to? Thank you.
Thank you, President. Yes, I have seen a lot of cases where, despite all efforts to the contrary and all pronouncements to the contrary in the LRA and every other piece of employment legislation, labor disputes are not timeously and expeditiously resolved. And yes, where dismissals took place 5 and more years ago, and they're coming before you as a labor court judge, and you're just unarchiving it or something, and you know that it's now going to take another year before the merits are actually heard. So I do think there's a crisis with delays, and that the system is not working the way that we hoped it would work when the Act was passed in 1995. CONAB doesn't seem to have worked. That section provides that basically every case should be set down for CONAB. I think unless it's probation or something, there's a very small group of cases that wouldn't automatically be set down for CONAB. But I find that employers routinely object to CONAB, and all that has to happen is that a letter has to be sent in, and automatically the two processes are separated. And in the early years, in the early 2000s, that didn't really matter that much because arbitrations were being routinely finalized within 60 days. And I think the wait for a labor court review was under a year. But now, I believe because of capacity issues in the CCMA and the restricted allocation of work to commissioners, the time taken from between conciliation and arbitration is now very much longer. And the time for review in the labor courts has also become much longer. And add to that the increasing legalism of the review process. I think all of those things have contributed to delays, such that, such that there really isn't a meaningful expedition in resolving labor disputes, as I believe was intended.
that being the case, what would be your proposed solution? I mean, there's no right or wrong answer, but in your opinion, what would be the right direction for us to go into?
Yes, a number of things would have to be present. Firstly, there would have to be fewer disputes, and that would be achieved by having a stronger labor movement. Where you have a strong labor movement, disputes are more often resolved at workplace level, and you don't find many hundreds of individual employees each inching their way through the statutory procedures. So a strong labor movement, a stronger CCMA with good interpretation, and people who, like I believe the cohort of 1995, 1996 commissioners we were all people who were pulled from a very fractious labor environment at that time. And we were all very clear about how important resolving labor disputes was. And there was a big emphasis, not just on sort of technical conciliation, where you say, would you like to settle? No, you wouldn't like to settle. Here's your certificate. That is what we had experienced under what was then the Department of Manpower conciliation boards. They would just almost certificate your case to go forward. When we first started with the LRA, there was a meaningful attempt to conciliate and to really intervene in the relationship and to really ensure that both sides understood that the CCMA would enforce the rights that were provided for in the LRA, both in favor of employers and employees. So, a strong union movement, better quality of conciliation, and then I suppose resources. One needs more commissioners, one needs more space, one needs more courts, I suppose, in the labour court, but that is a question of public financing. So, many of these things are beyond one's control, but I think all of those would help.
Thank you very much, Advocate Harvey. Thanks, CJ.
Commissioner Moimang?
Thank you, Chief Justice. Good afternoon, Advocate Pile, this side.
Good afternoon.
Just one from my side. Can you share with us your appreciation of transformative justice and how will you use? How can the labor court be used to advance transformative justice? I'm raising this point because one of the comments made by GCB appreciated the fact that you have devoted your career to utilizing law, particularly labor law, as a means to achieving social justice. If you could also just share on that point. Thank you, Chief Justice.
So thank you, Commissioner. If I've understood the question, transformative justice goes beyond just adjudicating who's right and who's wrong. It goes to restoring relations between people and affirming people's dignity and sense of agency in their own lives. And a justice system that is working properly will achieve that. I'm not sure if that answers your question fully enough, but if I've understood it correctly, that would be my answer.
Yes, look, I think your background, I suspect you will appreciate that law, like many disciplines, is part and parcel of the superstructure and is informed by the base. So obviously, in the South African context, there's a lot that is expected of all of us, three arms, to ensure that the rights as enshrined in our constitution, particularly your referral to Labor Relations Act, is used to address the historical past. So I expect you to share more. How do you use the bench to be able to ensure that the vulnerable and the marginalized get the necessary justice? Thank you.
the past, when people were divided, we were divided along racial lines, but along work lines as well. And so working class people were in the main black, not English speaking, and without access to power. And the Constitution aims to redress that, but we still sit here many years later with a lot of inequality in our country. And I'm not sure what to say to that. Law can transform society, but only to a certain extent. And legal rules, yes, they can only be used to a certain extent in transforming society.
Thank you, Advocate. Thank you, Chief Justice.
Chief Justice, could I just follow up on this question?
Yes, Commissioner.
Thank you, Chief Justice. I suppose, Advocate Hafi, this point about law at the crossroad of transformation, as posed to you, goes back to your history. I think that's why the Commissioner is saying that you've been at the forefront of using law as an instrument of justice in your work, for instance, for employees, so-called employees of labor brokers, in your work on behalf of farm workers, or both of those being extremely vulnerable groups that are super exploited. Even though your answer is an exasperated one about the limits of the law, but there is also a potential of the law, and it can be exemplified in what struggles have been engaged inside the courtroom and what have been the successes of those struggles. I mean, I think if we all shrugged our shoulders, then we must close this commission. But the reason we are here is because we think that there is scope for using the law to transform society. The question is, how will that happen? How have you done it in the past? Because the Commissioner is asking about your background. And what are you planning to do about it now that you're going to be a judge?
I think that goes back to that question of access to justice. The law can only be used to transform society if people have access to it. And I think I've spoken to that, and that has to do with issues of representation, issues of social power, issues of language. When it comes to being a judge, one of course sits in a completely different position. As an activist, as a trade unionist, as a citizen, and as an advocate, it has been possible to take on social impact cases that might not otherwise have been heard, that contribute to building the law and to modifying the common law. One steps into a very different position as a judge. As a judge, one shows up not as oneself, but as a functionary within the system, and one then sits as a representative of the overall legal system itself. And the system of precedent and the system of legal rules becomes very important. And that is important to appreciate, because without a commitment to the rule of law, the entire system won't work. So I think there's a big difference between being an advocate for transformative justice and being a judge who, in the greater scheme of things, is upholding the rule of law in the bigger system itself, so that it can function correctly and so that law can be knowable and certain and consistent for everybody who approaches the courts.
Are you saying that judges cannot be advocates of transformative justice?
They're not advocates of transformative justice beyond what is mandated by the Constitution and by the statutes that they wield.
Thank you, Chief Justice.
Thank you, Chief Justice. Good afternoon, Advocate Harvey.
Good
I'm
afternoon.
finding your answer particularly difficult in the context where the court you're applying for is the Labour Court, which is really the epicenter of transformative justice. And perhaps you'd want to just explain that again.
I am having difficulty with this question, Commissioner. Yeah, I really...
Justice, could I
really-
maybe also
sorry.
assist Commissioner Hassan? Sorry, I know it's difficult to find everybody.
Yes.
Maybe just to build on Commissioner Pilay's question. What we're trying to understand is whether you believe that the courtroom is a terrain or a space of struggle, or a space to actively, as an activist, fight for, whether it's restorative justice, you want to use those semantics, or whether we want to talk about systemic change, etc. So we're trying to understand whether you believe, maybe in some ways on an ideological level, whether the court is a terrain in which you can advocate that kind of activism that we know you fought for access for justice for, we know you're a trade unionist, etc., etc. So we just want to understand how that experience can imprint in your work potentially as a judge. Thank you.
Quickest, CJ? CJ? Just
Commissioner Malan?
the quickest addition. Are you a transformative agent?
Am I a transformative agent?
Are you an agent of transformation, put differently?
Yes, I would like to believe that I am, especially as an advocate who has taken cases that I believe are important and have had social impact, and I have framed legal arguments and come up with legal innovations that I believe have had the potential to transform in certain instances. I certainly don't believe that law is everything. I think transformation in society goes far beyond the law, but to the extent that it can be used to transform, I think that the Constitution and the LRA give us a very rich framework to do it in. But as I've been trying to point out, when one is a judge, one is no longer an advocate, one isn't bringing one's own cases to court, and one is constrained by the legal rules and by the rules of precedent. So I do see the two roles as distinct and different.
Has your question been addressed, Commissioner Pillay?
Not really, but I have a second part to the question.
Carry on.
Advocate Harvey, I was interested in your answers to the Chief Justice on your contribution to the transformation of the profession. Now, did I understand you correctly that you've never been briefed with a junior
Yes,
in any of your matters?
yes.
I was going back into your CV and I see that you say you appear frequently in the Labour Court, in the Labour Appeal Court, in the High Court. You've got multiple appearances in the Constitutional Court. And you're saying in none of those matters were you briefed with a junior?
I was never briefed with a junior, Commissioner, no.
And have you ever requested to be briefed with a junior?
I haven't, Commissioner. Generally, in most of my cases, especially the high-profile cases, I've been alone, and in many of those cases, I'm opposing quite formidable teams of silks on the other side, appointed by large and powerful law firms and large and powerful employers.
I accept that, but did you request a junior to be brought on to assist you?
I have not requested a junior.
You've never seen the need to ask for a junior on any of your matters?
No, Commissioner. I'm fairly junior myself, remember. I've only been at the bar. I'm in my 14th, I think my 15th year now, it's the 14th year. I've never requested a junior, and I'm not usually briefed by the sorts of clients who would be able to afford a second advocate working on a matter.
You see, Advocate Harvey, I understood you as saying that part of your contribution to access to justice is that you act for entities like Lawyers for Human Rights, the LRC, etc.
Yes.
That's your contribution to access to justice. And so in working for the LRC, LHR, etc., You've never asked to be briefed with a junior.
No, I haven't.
Thank you, Chief Justice. No questions.
Just to clarify on that, that work also has been pro bono work. So it wouldn't be a case of asking to be briefed with a junior. It would be a case of accepting to do the work pro bono myself.
Sorry, just a last follow-up, and I'm sorry about this. In your application, you go to great lengths to say that you recognize the importance of a source of work for youngsters. You put quite strong language, you set it out in strong language in your application. The importance of having access to work for people's dignity, etc. And so I must put you, I have a fundamental difficulty with understanding how, once you place emphasis on that in your application, you also place emphasis on the fact that you appear regularly in our highest courts, but you've never been briefed with a junior and you've never asked for a junior. The two, for me, are completely irreconcilable.
If I could just separate them out for you, Commissioner. When I mention work in that context, I remember the section that you're referring to. What I'm saying is that labor law, it's part of why I find labor law compelling and interesting. Some people think that it's just a very narrow area of law and that it's not particularly fun or interesting. But I find it a very important area of law because it intersects with a person's dignity in the sense that one's identity is tied up in the work that one does. And so when one is in trouble with one's employer or with one's job, that affects one's identity, one's role as a breadwinner, one's role as a family person or a parent. So that is, when I mention that, it's from the point of view of trying to interest other lawyers in labor law. And when I've given training, I remember I gave training at Tulamela Chambers some years back to try and interest young advocates in taking on pro bono cases. And I started with a slide that said, labor law is human rights law, because you find that a lot of people are interested in human rights law, but they don't realize that labor law is human rights law. So in my application, Commissioner, when I speak about work being an important source of identity and dignity, it's in that context that I'm explaining why labor law is a particularly rich branch of law to work in.
So when you say recognizing that work is an important source of human dignity, self-worth, and sense of value within family and community,
yes,
you don't mean that juniors around you would need work in order to have those sort of comforts, a sense of dignity, a sense of self-worth, etc. And that as a senior in that space, you've got a responsibility to ensure that you firstly transfer skills, but secondly also bring juniors onto matters so they have a source of work.
That isn't what I was writing about in that section, Commissioner, but I acknowledge what you're saying and I agree with it. But I do repeat, I suppose, for about maybe too often, that I have not had the opportunity to be briefed with a junior. I haven't been in a position to ask a client to brief a junior because in those matters, clients have only been able to afford one advocate.
Follow up, CJ.
Where's the camp? Oh, yes, Prof.
Advocate, I'm having serious difficulty in understanding you, and perhaps maybe just for my understanding, if you can just assist me. On the one hand, you are saying that you are an advocate of all the values that you have been speaking about, right? On the other hand, you are speaking about you doing pro bono matters. And on the same breath, you are talking about payment. My understanding about pro bono is there's no payment. Am I wrong?
That is correct.
Yes. So you are doing a public interest matter. You have been briefed by a public interest institution to do a matter that will potentially be reported. There's no issue of affordability there. Perhaps maybe if you win, whatever institution can say, whatever cost, they can be paid to you. as is normally the case. So under that context, you have not seen a need of saying, can I bring a fellow person who can actually benefit from this process? That's how I understand this transformative argument from a constitutional point of view coming from. That, if you can just clarify me on that, because I'm very confused of what you're saying.
Yes, Commissioner.
Sorry, before you answer, to expand on that issue. You did ask me to lead you in the Constitutional Court once, didn't you?
Yes, Commissioner.
All right, so then maybe, I don't know if that is transformation or not, but at least maybe it's something that helps you. Okay,
Are we
feel free to
answering
mention.
questions for candidates now, Commissioner Ngqetho? I have a strong feeling that that candidate is well able to speak for herself. So let's please let her answer for herself.
I withdraw that, Chief Justice.
And of course, in that matter, Commissioner Toby, I was your junior, not the other way around. Commissioner, yes, maybe what I haven't made clear enough is that I have been very interested in encouraging young advocates to be interested in labor law. There aren't a lot of young advocates at the Cape Bar who are interested in labor law. If there had been, they would have definitely been brought on board. It's not as if there are lots and lots of junior advocates who are just dying to do pro bono cases. It's been incredibly difficult to find counsel for cases, and a number of cases have been offered to me about very important issues that I would have loved to have taken up myself, and counsel has not been found to take on those cases pro bono. So if it is your impression that there are lines of people waiting to take on these very important and socially impactful pro bono cases, I'm afraid you're mistaken. That's not the situation that we're in at the moment in the legal profession.
Commissioner Nkonyane?
Yeah, thank you, Chief Justice. Good afternoon, Advocate Harvey.
Good afternoon, Commissioner.
I was going to ask this question as the second one, but because of the line of question before me and your response, I feel I must ask it now. I noticed that you have been recommended by about 5 senior counsel. Are you in a position to tell us on what basis? Did you work with them, that type of thing?
They're all senior counsel that I've worked against, actually. I might look at the list again now and just think about it, but they are people who were familiar with my work because I had appeared in the same matters with them, but on the other side.
So they were your opponents?
Yes.
Okay. Anyway, the question I wanted to ask you first is what I see as a missing link in your career path. Perhaps you will clarify. I noticed then that in 1991 until 1994, you were with Wits East NUMSA.
NUMSA, yes.
Yes, but thereafter, you then went and worked as a full-time commissioner of the CCMA in 1996. That period after you left NUMSA and the period when you assume your responsibility, I see a missing link there. Where were you and what were you doing?
My first child was born in 1994, Commissioner, and I was at home looking after her. At some point during that period, I trained with IMSA as a mediator, and then I was invited to take up a position at the CCMA in 1996.
Thank you, Chief Justice.
Commissioner Hassan, your hand was up at some stage. Did the follow-up question cover you? All right. Commissioner Matolo Dlebo?
Thank you, Chief Justice. Advocate Happy, I think I was, whilst we were answering questions from Advocate Pillay, I was a bit worried that do you really understand what transformation is all about and skills transfer? And moreover, that you can't even, I just need to understand how do you reach out to young black advocates? Because I see in your documents you seem to have said a lot about transformation. I just want to understand the link, how you do it, because from what you are telling us, I'm not sure I hear you properly.
You want to know how I reach out, Commissioner?
Yeah.
By engaging with advocates at the bar. There's a very small group of advocates at the Cape Bar who do labour work. I'm always excited when I see somebody come along who wants to do labour work because it gives me somebody to talk to and somebody to work with. So that's how I reach out, is by having relations with those council, by dropping into their chambers, asking them questions. They come into mine and ask me for help with their cases. So that is how I interact with other council who are interested in labour law. I don't have an attractive practice in commercial law or other types of law that many young council are interested in, and so I'm not in demand, as it were, for that kind of work. And that is why I've put my effort more into advocacy training, and I have made the point earlier in this interview that I feel that transformation goes beyond access to work into the question of access to justice. That is my answer to that.
Sorry.
Yes.
Have you finished now?
Yes, thank you.
All right. Commissioner Matulaship.
CJ, I'll leave it there.
Okay. Commissioner Matthews?
Thank you, CJ. I just a quick question. I understand that, like in this discussion with other commissioners, particularly regarding black involvement with Black Council, the role of an advocate, I know you are not choosing who the client must be and who must be, but what do you think the advocates, particularly senior advocates or senior junior, would play in advancing transformation in the area of briefing? How would you encourage, what do you think should be done in that area, or what would you advise?
It's a difficult question because, as you yourself point out, as advocates, we don't influence briefing patterns. And as a junior female counsel myself, I've found that I haven't always had access to the kind of work that I might have wanted. So I'm not sure how one addresses that, other than possibly having the judiciary itself do more to encourage legal teams to be more representative and to encourage senior advocates to allocate substantive portions of the work to juniors rather than simply having them on board in name only. And that is why on those two occasions when I have found juniors who really were interested in labour law, and in fact in one of those occasions I did ask the client whether we could bring one of them on as a junior, but the client said no. That is why when I've had those juniors interested in cases that I've been doing, I've given them a substantive portion of the work, including the drafting and also the presentation of argument in court. And on those two occasions, I've shared my fees with them because they needed, their contribution had to be recognized and properly valued.
Okay. Thank you.
Anyone else, colleagues? Commissioner Kane?
One short question, if I may. Good afternoon. Assuming you are not recommended at this stage by this commission, it is the stage in your career at the bar where one would ordinarily apply for silk. Are you intending to apply for silk?
I think that I probably have another year or two before I'm sufficiently senior to apply for silk at my bar. But my main aspiration is to come to the bench. If I were not appointed to the bench, eventually I'm sure I would apply for silk in the next few years. Yes, Commissioner.
Thank you.
All right. You'll correct me if I'm wrong. Judge President Mulahle, he wouldn't press this issue with you, but I just got a hint of a sense that he has certain concerns. I even thought to myself, maybe he thinks he found you to be aloof, but there's just something that he would not come out and say. And I say this mindful of the fact that being a judge is one of the most solitary jobs in the world. And when you are acting as a judge, you have the added pressure of not wanting to put a foot wrong, and there's lots of work for judges. So keeping to oneself, may not mean anything untoward. But I still would want, especially that you have not sat for any real period of time on the bench, I would still want reassurance from you that you understand the importance of collegiality on the bench.
Yes, thank you, Chief Justice. I really do understand that. I work best in groups. I don't particularly, one of the things I don't like about being an advocate is being all on my own. In Durban and Cape Town, it's very easy because there's only one other judge, and one goes to that judge's chambers in the morning, and it was Judge LaGrange usually in Cape Town, and it was Judge Witcher in Durban, and I had very good relations with both of them. Johannesburg was a completely different situation, and Chief Justice, yes, I felt that I was new, I was very junior. I didn't feel that I had the right to impose on anybody, so I just worked very hard in my bubble and tried to stay out of everybody's way. It was in no way intended, and I'm sorry that I seem to have come across as aloof. I'm absolutely not aloof. I'm very sociable and quite gregarious. And I absolutely understand the importance of that, and I value it enormously. As I say, it's much easier to work in a collegial environment where you can go to your colleagues and say, I've just had this difficult case, what would you do, or what do you think I should do in this instance? So I am somebody who prefers to work like that than alone. And I think that's one of the things that would be very enjoyable for me if I were to be appointed to the Johannesburg court, is that it is a big court with a lot of judges and a lot of scope for that sort of interaction. And I would enjoy that and benefit enormously from it.
All right. Last one. You and I are the same age, 61. Ooh, just gives me horrors just to say it. And some in this very room might consider that advanced age, which maybe it is, to be starting a new career path. If you are appointed, how long would you still have to serve on the bench?
Well, Chief Justice, as you will have seen, the GCB very kindly pointed out my age, and they counted for us that it would be 13 years and 9 months, I believe. And I think I have two things to say about that. The first is that, as I've mentioned, when I went back to university in my 40s, it was because I had the aspiration to become a judge. And from as early as 2015, I made that aspiration known, and I made it known that I was available to act, and I actively sought an acting appointment. But it was not to be, and it was only in 2021 that I was first given the opportunity. I would have loved to have done a lot more acting, and I would have loved to have come before this commission before today, but I was advised that until I had had a proper acting stint, I should not be thinking of applying for a judicial appointment. That's the first thing. And the second thing is that, well, now that we all know my age, I feel fine, I feel great, I feel full of energy. I'm happy to start a new chapter at this point. And I come from a very long-lived family My father was very vigorous and active until well into his 80s. And if I'm lucky, I'll be fortunate enough to follow that path, and I'll be in my right mind for many years to come, Chief Justice, hopefully.
No, thank you for saving our honor. Any further questions for the candidate colleagues? No? All right. That's the end of your interview then, Ms. Harvey.
Thank
Anything
Chief
you want to
Justice.
raise with us before you leave?
That's it, Chief Justice. Thank you for the opportunity.
You're excused.